So now on to the final thing in the agenda, which I know we have all been waiting for, our keynote panel. So Michael and Loren, I will now introduce them as they make their way up to the podium. So I'm delighted to introduce Professor Michael Graetz and Loren Ponds. Professor Graetz is the Isidore and Seville Sulzbacher Professor of Law and Columbia Alumni Professor of Tax Law at Columbia University, as well as Professor of Law Emeritus at the Yale Law School. And Loren Ponds, who is a tax partner at Skadden here in DC, specializing in international tax. Both are experienced and accomplished tax lawyers, and if I gave them the full introduction that they both deserve, they would have no time to speak, so I am not going to do that. I'll just hit some highlights. So in addition to being a law professor at UVA before going to Yale, Michael served as assistant to the secretary and special counsel at the Treasury Department during the administration of President Bush 41, that is Bush the Elder, having previously served as Treasury Deputy Assistant Secretary for Tax Policy. The most recent of his 11 books is The Power to Destroy: How the Antitax Movement Hijacked America. He has also published many articles on a wide range of tax, political science, and related subjects. He has received numerous awards, including the Treasury Medal, the Daniel M. Holland Medal from the National Tax Association, and has been a Guggenheim Memorial Fellow. But he also received an award from Esquire magazine for courses and work in connection with the provision of shelter for the unhoused. Michael also served in a number of other capacities in IRS and the Commissioner's Advisory Group, but as I said, if I listed everything that he has done, he wouldn't have time to speak, so I am now going to go on and say a few words about Loren's background. Loren has also had a varied and career spanning a range of practice venues. Before becoming a partner at Skadden, she was a partner at Miller and Chevalier, and also here in DC, where she co-led its tax policy practice. She has also worked on the Hill as majority tax counsel to the U.S. House of Representatives, where she developed, analyzed, and refined the international tax provisions of the Tax Cuts and Jobs Act of 2017. Earlier in her career, she worked at a global accounting firm in Washington, D.C. and Dusseldorf, in their Washington and Dusseldorf offices, focusing on transfer pricing and tax controversy. She is fluent in English, French, and German, and worked as a trainee in the OECD's office in Paris, as well as serving as a fellow of the Alexander von Humboldt Foundation at the University of Hamburg in the International Tax Institute. And now, Michael and Loren are going to discuss Michael's recent article, which was published in Tax Notes earlier this year. It is titled Sovereignty, Sins, and the Reassertion of Primary Taxing Rights by the United States. And if you haven't read it yet, it is part of your meeting materials, so you can easily access it. It makes wonderful reading as you go back home or later this week. So with that, I'm going to turn things over to Michael and Loren, and you take it away. Thank you very much.
Okay. Thank you, Alice. Thank you, everyone. We are really excited to be here and looking forward to what proves to be a lively discussion of Professor Graetz's paper. understanding that many in the audience probably will not have read the article yet, we're going to start with an introduction. So Michael, maybe you can give us a few words as a way of background.
Yeah, I should begin by saying that I'm used to standing at podiums, and the idea of a fireside chat about international tax issues is sort of new to me. But that's the way Alice wanted to do it, and we do whatever Alice wants. And it's also a particular pleasure to follow Eric, who I've known for a very long time, and a fellow Atlantan who is always hard to follow Atlanta speakers, but I really appreciate what you're doing. But as Monty Python would say, now for something completely different. I should also say, just at the outset, that I've never sort of written a book or an article, and I've written many, that I didn't feel like I could write differently or better after I'd published it. But if you do that, you'll just write one article over and over again. I know people who have done that, but it wasn't what I wanted to do. My goal in this particular article was to try to begin to get people to think about how the U.S. might reclaim its primary taxing rights, especially over intellectual property income, when the IP is created and developed here, mostly by U.S. multinationals. The big problem is that the current system continues to have shortcomings even after the 2017 legislation, and I don't think we've thought about them quite deeply enough. So here was the problem in 2017. The problem was that the international tax system had become archaic. It was using and still uses rules and concepts that were developed in the 1920s, more than a century ago. And it sometimes seemed to, well, it certainly seemed to allow and often seemed to encourage U.S. multinationals to shift their income to lower tax countries somewhere else. Before the 2017 legislation, this problem was very difficult for Congress to solve, and I never quite understood why, but I think I do now. And that is that with a 35% rate here and zero or near zero rates elsewhere, it was very hard for the U.S. Congress to tell U.S. multinationals that they really had to pay the 35% tax in contexts where they were competing abroad with foreign multinationals that were paying far less. And so we were stuck until 2017. And between 2010 and 2016, a group of economists, mostly at the Commerce Department, said that there was $150 to $200 billion a year that was shifted abroad from 1982 to 2016. 38% of the income of U.S. multinationals, they said, should have been reattributed to U.S. GDP. But the system couldn't be readily changed for the reasons that I've described, but also because the ability to defer income that was abroad and get tax credits when you brought back income, really sort of the system justified the idea that you were going to support the U.S. multinationals. And what's happened over recent years in this field is that multinational tax avoidance, which used to be something that you read about, if at all, in the newspapers on the business pages, and that would not be a topic for conversation beyond a group that I used to call the International Tax Priesthood, moved from the business pages to the front pages. And a member of the Australian Treasury who I met said to me that it had become a topic for barbecue conversation in Australia. So that tells you how it mustered its political force. And the idea of international tax moved from the offices, I guess, of the finance ministers and the tax administrators into the offices of presidents and prime ministers. and the political salience of the whole issue changed dramatically. So in 2017, Congress responded, and it responded by lowering the U.S. tax rate to 21%, and eliminated the barriers for U.S. companies to repatriate their income back to the United States. It introduced a first global minimum tax called GILTI, for those of us in the business, at around a 13% rate, scheduled to increase to 16.4, but that seems unlikely today. It provided special rules under something called FDII, or FDII if you prefer, which allows a low rate, also around 13% now, on IP that is here that is used in goods and services abroad, to put it simply, and was intended to encourage U.S. multinationals. Some did this to bring their IP back to the United States, but many did not. Then the OECD came in with what it called its two-pillar project. And I'm going to skip over pillar one because everyone I know says it's dying or dead, and so I'll spare you that. But pillar two, which is neither dying nor dead, is designed to create a 15% minimum tax on income of multinationals around the world. And more than 70 countries have adopted this minimum tax. And most of the 70, I think, are found in Europe and the Asia Pacific, for those that are thinking about U.S. trading and investment relationships. The three big countries that have not done it are India, China, and the United States. And the United States has been very opposed to it of late. And during the Biden administration, the U.S. Treasury supported the Pillar 2 effort. Janet Yellen frequently said that it was designed to stop a race to the bottom among tax rates. But as a result, if you ask where are we today, we're in a position where a U.S. multinational is supposed to be taxed under U.S. law at 21%, but many obviously managed to go below that, probably due to your efforts in part. And the rest of the world is collecting a 15% tax. And I don't think we've thought about how that changes or how substantially that changes the way we ought to think about international tax rules. And so while the big question looking backwards was, in part about the competitiveness of U.S. multinationals, the big question going forward is which country is going to get the money from the multinationals? Where is the revenue going to go? Under the status quo, with no Pillar 2 conformity here, a lot of the money that I believe the U.S. should be claiming for itself is going to go abroad. And so that's the problem. And given declining labor force participation and aging populations everywhere, everybody needs and wants the money, which is also a change from the post-war era. And so we're in a position where we're going to need the money, and as everybody in this room knows, Congress is now considering a $4 to $5 trillion addition to the deficits, and we're going to need it more than ever after we get through that exercise. Just to put it in context, our interest payments on the federal debt as a share of our economy are now the highest in the OECD, 6 times higher than Japan's, which has a much higher debt to GDP ratio because they've got a much smaller economy, but we're paying 6 times what they're paying in interest. And China spent less than 1% of its GDP on interest in recent years. So it's the interest on the federal debt that I think we ought to be focused on more than anything else. And the Committee for the Committee for Responsible Budget, I say that because I always trip over the idea of a responsible budget. But the Committee for Responsible Budget estimates that extending the tax cuts of 2017 and adding some of President Trump's campaign proposals would add $1.1 trillion in interest costs, another $250 billion a year over the next decade, and will raise interest costs to 4.6% of GDP. So we're paying about twice as much, or a little over twice as much, in interest as the economy is growing each year. We're spending all of our growth plus on interest. These are the legal changes. The other thing I just want to mention by way of introduction are the economic changes that we're now facing. And the economy, as everybody here knows, is very different than it was in the 1920s. The globalization of trade and investment is important. The role of IP, its ubiquity, its mobility, create a very different economy than any that we've had before, and certainly than what we had when the international tax rules that we now live with were formulated. The most important, in my mind, the most important piece of mobile income is IP income, although others will point to interest income and some others, but IP income, I think, is the one to focus on, especially when the IP is from production and development and management and creation here. And so that's the subject of this rather short, at least for me, article. There are many culprits in the current law. I refer to them as the sins in the title of the article. But the one that I focus on most is the allocation of income from U.S. IP to foreign countries, which continues apace. And one of the reasons for that is that we say that the source of that income depends on where the IP is used and not where it is created or developed. That rule, which I explain in the article and will not go into, was a complete afterthought when the source rules came up in the 1920s. It followed rents, where you're talking about immobile property, and nobody ever thought about it. So the most straightforward way to deal with this would be to tax currently IP income from abroad under what is subpart F of the code. I'm grateful that others mentioned sections that I didn't know, so I can mention a section that maybe some of you are not familiar with. But subpart F basically says that income abroad is taxed currently in the United States, and we allow a foreign tax credit for the foreign taxes paid. It was created in 1962, and in 1962, the House would have taxed IP income that was earned abroad as subpart F income. And in 1993, there was a provision that actually passed both the House and the Senate that would have done that, but it never went into effect and was repealed in the late 1990s. I mean, the other thing we could do, mimicking, I think, the UK and Australia and some others, is to call the IP income over there diverted profits, and then that will remove them from some of the constraints that people feel if you call them actual income. I have no position on that question. But I think there is a question about how to treat foreign taxes, especially when you think about the fact that many countries abroad, particularly in Europe and elsewhere, have what they call IP boxes, and they tax income from IP at much lower than their statutory rates, in the 5 to 10% range, to put it generally. And then I think that, and the article argues that more fundamentally, over time, the U.S. should really consider saying that the source of IP income that is developed and created and, made here should be taxed here. And we should change those source rules. Hard to do, but I think important. And a century of bad rules probably is enough. I guess the other thing to say is that there are great simplifications that would occur. There are rules about allocating R&D expenses under the foreign tax credit. There are questions about whether you're going to grant R&D for research and development abroad and so forth and so on. But the basic point here is that, and this, seems a little unlikely in the current climate, but if Congress gets around to reconsidering the international tax rules in a serious way, it ought to think about this in a much more fundamental and basic way than it has in the past, which has been limited to incremental change. So I have to say I've taught at places with very smart people for many years, and I'll give them things to read, and I know they won't read it. So don't worry about reading this article. It will not offend me if you don't, but at least Tax Notes has made it available to you if you're tempted. Loren.
All right, thank you. That was really good. A good overview. For those of us who have read it, I can confirm. So we have some questions to get into. We don't have a whole lot of time, so I'm going to jump right in. In your article, you note that concepts such as capital export neutrality, capital import neutrality, and capital ownership neutrality should no longer be central to our framing of international tax policy solutions. Arguably, our current international tax framework is a hybrid capital export neutrality, capital import neutrality system, which in your view does not sufficiently deter the offshoring of valuable income-producing IP. What are the limits of these old concepts, and how do your proposals fit into them, or how do they not fit into them?
Okay, so for a word for those of you who are engaged in practice outside of the international tax business, capital export neutrality basically says that you should tax income the same whether it's here or whether it's abroad. It was a concept developed by an economist in the 1960s and has been a very important idea in international tax policy beginning in the 60s, I would say. Capital import neutrality says that two companies from different sovereigns should be taxed the same on the income in wherever they're earning the income in the source. And capital import neutrality is about competitiveness that I described earlier, I think, for those of you who are not deeply into the economics business. They're both worldwide concepts. And I think the first article I ever wrote on international tax, I said at the end that the only way that you can have both of these together at the same time is if all the countries that are involved have exactly the same tax system, the same rates, the same base, and so forth. You can get both of them. But there's an impossibility theorem that says you can get one or the other, but you can't get both unless everybody's got the same tax system. Well, I had a law professor that says that if you believe that everybody's going to have the same tax system, you'll never own your own home. And that's right. And so everything can be a compromise between CIN and CEN. And Congress justifies whatever it does as sort of compromising between these two opposing forces. And I said in this article long ago, so I predate, just to be clear, America First notions, that politicians are going to look at the question of how to improve the well-being of their citizens and residents. And they're going to look at it from the perspective of what's good for their country. And that's the way we ought to start thinking about this, and then we'll negotiate with other countries if need be. And so that was one fundamental reason, which was that we're never going to get both of them, so why do we keep trying to say anything is a compromise? But the other point, which I made before, and I won't repeat it, is that it was very hard to say that we weren't going to let U.S. multinationals compete abroad by taxing them at 35% when they could get 0 or 5 or 15 or 12.5 abroad. And so these are, in my mind, they're archaic and not very useful, I suppose is the way I would put it.
Okay. And to follow up on your observation that politicians are going to do what's in the best interest of their constituents, in the paper you assert that Congress should address international tax issues from the perspective of our nation's welfare, the best interests of U.S. citizens and residents. So we are currently in the midst of some tax legislation in which retaliatory measures have gotten a bit of airplay. Why aren't these an effective means of putting America first?
All right, well, let me say two things about this. One is, there's been a lot of discussion that the OECD and its pillar projects, 2 pillar projects, I guess after Sampson, is an infringement on US sovereignty. And nothing in these 2 pillars stops the US from doing whatever it wants. They require unilateral action, and especially the 2 pillar project. And so Congress, and particularly the Republicans in Congress, have been expressing how the OECD and international organizations are threatening US sovereignty. Now, I wouldn't say this to them, but I'll say it to you. If Congress is really worried about its sovereignty, all it needs to do is look up 16 blocks to 1600 Pennsylvania Avenue and not look across the Atlantic or the Pacific for threats to its own sovereignty. But that's my view. So the sovereignty argument, I think, is a red herring. On retaliation, so income tax is really a tiny tail. I know for us it's the whole dog, but it's a tiny tail on the tax dog, and it's particularly a tiny tail on the issues of the Western alliance and compared to trade and investment flows. And so we're in a moment where the US government is in a retaliatory mood. And we're retaliating, we're talking about retaliating through tariffs for offenses that the current administration sees in the trade context. We're talking about all sorts of other foreign policy issues in the global context. And I just think it's important to recognize that the Biden administration, and here I'm talking about the National Security Advisor, the State Department, Commerce, and the Treasury, the Secretary of the Treasury, really thought that the Pillar Project was a way to rebuild the Western economic alliance, which they thought had been shaken a bit from the previous administration. And now we're in a very shaky situation. And the idea that we should come up with some income tax retaliation rules for something that's going on because of the minimum tax that's being imposed strikes me as taking a very narrow lens to a very big problem. And the last thing the Western Alliance needs, in my view, is a new place to fight about retaliation. So I argue very strongly in this piece that it's the wrong moment and the wrong answer if you're going to think about we should retaliate because they're putting a minimum tax on money earned in their countries by US companies.
All right, thank you. Well, we'll see more, right? There's certainly, the chairman of Ways and Means has a retaliatory measure that he has introduced. We'll see if it makes it into legislation that's set to be marked up.
Well, the Ways and Means Committee is important to say, for those of you who are not following this game, the House Republicans have a new retaliatory measure. There's some retaliatory pieces in the Internal Revenue Code that nobody will use because they're too blunderbuss and they don't work. But there's a new one.
Right.
It's a little less blunderbuss, but I don't think it's going to work. But maybe it will. But we won't get into that here because I think the basic idea of using retaliation in this context is a mistake.
Yeah. Okay, let's move on. A cornerstone of your paper is advocating for a revamping of our current sourcing rules, specifically that income generated from U.S. developed IP should be sourced to the United States. Are there compelling reasons why we might want to maintain status quo with respect to the sourcing rules as characterized in our double tax treaties? In other words, should we instead reimagine in what circumstances we might want to cede primary taxing rights and in which circumstances we might not?
Well, when I served in the Treasury, we treated tax treaties as if they were really very important. Even though I was reminded then and again this morning about a comment that the Chief of Staff of the Joint Committee made during the 80s when he was involved in legislation overriding tax treaties around the world. And he said, when I talked to these people who negotiated these treaties, you'd think it was Dutch, referring to Ronald Reagan, and Gorby, referring to Gorbachev, in Reykjavik, negotiating over nuclear bombs. And the point was that the issues that are at stake, I think, in tax treaties are fairly low stakes these days. And so my attitude about the tax treaties has really changed over time. I think that in the first place, we have 2,000, I think, bilateral tax treaties. They're all, the whole arrangement from the 1920s was bilateral instead of multilateral. They're bilateral treaties around the world. They all lose revenue. Let's start with that. None of them raise any revenue. They were negotiated by people who are enamored of CEN and CIN, which we've talked about. They were very important in developing an international tax system from the early 1920s through 2010 maybe. I don't know when they became less important. But they don't deal very effectively with source rules. People really are now saying, well, this is our money, and they're doing it unilaterally. They deal with withholding taxes, which you could do in a much simpler document. And they deal with administrative dispute resolution and exchange of information, which the government has done for years in very short, not terribly technical documents. And so I think the treaty process has broken down, and I think the OECD's efforts, beginning with its first projects at the early part of the 21st century through the two-pillar project, is just evidence that the treaty process is not really fit for purpose today. But I know others, including you, feel differently.
I still feel strongly about reserving treaties, but I take your point. Of course, we can observe many instances in which countries are imposing tax rules that fly in the face of treaties that they have negotiated with us and other countries. And so I think the question becomes, do we work to preserve what's in treaties, or do we cede to the reality of today and find some other way to move forward?
So I think this is a great question. I hear rumors, it's probably in the press somewhere, but I didn't see it, that the U.S. is thinking about negotiating a tax treaty with China. My view about that is, how are you kidding yourself? I mean, you have a tax treaty with China, and what do you think China's going to do? Well, it owns most of the enterprises in China, so it'll just do what it wants. The ones it doesn't own, it will influence either through subsidies or limitations. And when you bring your IP into China, it will either take it or require you to give it to them. And so what's a tax treaty going to do in terms of stopping China from doing whatever it wants in this field? I wish I could be more optimistic about that, but the last thing I would do if I were back at the Treasury is start tax treaty negotiations with China. I don't know how many dolls that would involve, but I'm not for it.
And so instead, do you think it would make more sense to have a scaled-back treaty network, mainly for double tax case resolution, looks more like our TIEA?
I do. I mean, I think it's important. I think rethinking dispute resolution procedures and arbitration and multilateral negotiations, which are often important, is very important. We ought to think about that anew. Mm-hmm. and that, dispute resolutions need to be solved out of court and, bilaterally or multilaterally, so that's very important. And information exchange is obviously important, but information is coming and information is going to be public. I guess the other thing to say is that, there's reporting rules that are going on now in Europe and elsewhere that are going to make the international tax policy avoidance conversation much more salient than it has been over the last decade, because there's going to be a lot of facts. And my guess, is just a guess because I don't do this work, is that some of the facts are not going to be terribly pretty for the multinational community.
All right, let's get back to sourcing. So you assert that resourcing IP income to the country where it's been created or looking through to where IP has been principally developed to determine source is the proper approach. This sounds a lot like value creation concepts. What are you thinking when you're making these statements? Is that an endorsement or maybe a suggestion that we should enlarge or narrow that concept?
So the OECD in its first project, which was very incremental, the BEPS project as it's called, base erosion and profit shifting for those of you who are not in the lingo, it stuck very close to existing knitting in the international tax area. And it's gotten away from that now. And, and then the question is, what are we going to do? How are we going to get IP back to the U.S.? And my understanding is that after the 2017 Act, you had a minimum tax on income abroad, the GILTI provision. You had a subsidy or a lower rate of tax, if you prefer, on IP income that's used abroad. And a number of big companies brought their IP back to the United States in some fundamental way, but a number did not. A number went from Bermuda to Ireland, for example. I won't name names, but you could probably figure out who they are. That's public information. And if you look at the Irish tax receipts and the Irish GDP, these companies are very obvious. They're U.S. multinationals that are contributing way more than their share of tax revenue to Ireland and way more than their share of IP to Irish GDP. So it's a start. And the question that I was really addressing in the article is, having started there, where should we go? There were proposals in the Biden administration to raise the rate on corporations and raise the rate on FDII. And I think that the FDII rate should stay below 15% or right at 15%, so it's competitive with all of the rates elsewhere, a little under maybe. And I hope it will be more effective. I think there are reasons why the IP doesn't come back, which I will not get into in some cases, but we really have to think about it. And then, as you point out, I say, well, if that doesn't work, let's just claim it and say it's our income and, your move. We're going to tax it, and then we'll talk about foreign tax credits for it, or we'll discuss how much of it you get, and if you've got a market country, we'll negotiate about that. But it should be sourced here. It was developed here. It was created here. It's ours, and it should have been sourced here. If it was important, it would have been sourced here, the same way that interest income was sourced to the capital exporters when the UK and the US were negotiating the first tax treaties in the 1920s. It's just that was important then, this is important now.
And what about, I can see that world where we say, all right, it's ours, it's sourced here because it was created here. But we also have had years of arguments of, contribution to value by virtue of the size of the market.
Sure, value creation.
Yes, yeah.
I'm sorry, I missed that.
That's okay.
You said it, but I missed the value creation point. So OECD in its first effort said we're going to decide where income belongs by where the value is created. Okay, Well, the value is created by everything that goes into creating the value. And so then the question is, how much did each element contribute to that value? And I would argue that what I'm urging, which is that the U.S. claim its source basis for taxing income that is essentially created here is a value creation method. It's just weighting very heavily where the IP is developed and created and managed and so forth. So I think it's within the context of value creation, but the value creation, like formulary divisions of income, it's just not a solution. It's what's the next question?
It's a concept. So we start with 100 and then decide how much.
We get 100 and who gets how much of it. But I think that we should be getting a lot more than we are. I guess that's my value creation comment.
Okay, I think we have 4 minutes left. I want to leave you time for your concluding remarks. So maybe one question. You touched on repatriation of IP after 2017. And the White House recently publicized its priorities for the upcoming tax bill, among them a reduced FDII rate, at least for the next 4 years, so 25 to 2029. And in your article, you noted that as a part of the expansion of Subpart F to include foreign source income generated by U.S. developed IP, it may be appropriate to have a new separate limitation basket for IP income or low-taxed income more generally to further encourage the repatriation. Why do you think that the combination of GILTI and FDII fell short in encouraging U.S. MNEs to repatriate IP, or will continue to fall short even with a lower FDII rate?
Well, I mean, why do I think it fell short is because it fell short. That is, big companies didn't repatriate, even though some did. So this is just what my 4-year-old grandson would say is just the way it is. So the concepts there remain don't work. Incentives. Yeah. So let me just say one thing. The Pillar 2 project assumes that if you only average income per country instead of averaging it worldwide as we do under our system, you're going to stop a lot of this problem. But if you look at per country tax systems, they have 2 different tax systems. They have low rates on IP and they have normal rates on other income. And so the averaging intercountry will also continue with all of these rules, even with Pillar 2. I don't think that's a silver bullet in the way that a lot of people in the international community do. So I think it's going to continue, and they're clearly, you move your IP from a place where it's not going to be taxed when it's sold, and you get a new basis that you can amortize over a number of years in another relatively low tax country. There are lots of opportunities for continuing to shift IP abroad, and they're often advantageous. And I guess what I'm saying about the foreign tax credit is we really ought to think seriously about saying if it's low taxed IP income and it's taxed at 5%, deduct it instead of getting a credit for it or something. I mean, if we're going to, the Congress was talking until this week about repealing the state tax deduction. For corporations. Well, if you're going to repeal the state tax deduction, you really need to rethink the foreign tax credit, which we haven't done at all. But that's sort of where I ended up on that one.
Okay, good. All right. Well, I will turn it back to you for some closing thoughts.
Well, I've given you most of my thoughts, but I really want to put this in a broader context and return to the question about interest on the federal debt and the budget situation. So our interest on the federal debt now, as I said earlier, is hitting 4.1% of GDP, even if the tax cuts that are about to be extended were not going to be extended. So it's going to go up. And the CBO estimated recently that if you get a 1 percentage point increase in the interest rate from the ceiling of 4.1%, that 3 decades from now, the interest will cost $11 trillion a year. And the question I keep asking, and nobody has a good answer to it, including me, is how can this happen without stimulating a fiscal crisis, stymieing economic growth, inhibiting our ability to provide for the American people, and especially when 30 to 35% of every dollar of interest is going abroad. And so we really need to get our budget in order. And as it did in the past in the Clinton administration and the George Herbert Walker Bush administration, the only way to do that is a serious combination of additional revenues and spending cuts. But the current Congress and administration seem determined to spend $5 trillion or more, and then just to do it in a way that's a deceptive paint-by-numbers exercise that disguises the cost of it from the American public. And so that's where we are. I'd like to leave, I know I've got 1 minute or 30 seconds, but I would like to leave you with something useful. I was giving a talk on my most recent book at UCLA, and somebody in the audience stood up and said, well, we're saving all this money, we just saved $50 billion on USAID. It was right after Musk had cut the USAID program. And so I thought I needed to come up with a way to leave you with something you can actually use that will explain the federal budget to a lawyer, and particularly the difference between millions and billions and trillions, all of which unfortunately rhyme. So here's the way I explained it. If a lawyer earns $1 a second, he or she will earn $3,600 an hour, not bad. At 2,500 billable hours a year, that's $9 million a year. To earn $50 billion, which was the USAID number, the lawyer would only have to work 1,585 years. But to earn 5 trillion, 50 sounds more than 5, to earn 5 trillion and pay for the tax extensions, the lawyer would have to work 158,500 years.
Thank you.
Thank you so much for this wonderful discussion, and really read the article. It's terrific. And so with that, we are at the end of our program. We look forward to the virtual 2025 fall meeting, and we hope to see you again in person in San Diego at the mid-year meeting in January. Thank you very much. Have a great Mother's Day tomorrow and a safe travels home. Thank you.